Hello, I am Neeraj Tiwari, Assistant Professor Law, National Law University, Delhi, and I will be presenting module on reporting of crime. To begin with, let us know first the learning objective of this module. First, the object of this module is to acquaint the learners to the necessity of crime reporting. Secondly, to expose the learners to different modes of crime reporting under the Code of Criminal Procedure. Thirdly, to acquaint the learners with the implications of crime reporting. Fourth, to explain the learners certain offences which require special reporting. And lastly, to explain the learners how reporting of crimes sets the wheels of justice in motion. Every criminal behavior may not reach to the formal system. The victim or informant may be too poor or too ignorant to report the crime to the formal system. At the same time, the victim may be too far away, unconnected with the modes of communications. Such criminal incidents remain unreported and constitute the dark figures of crime. However, quite a few crimes, particularly in urban areas that have better resources and awareness, do get reported and come to the knowledge of formal system and constitute the crime record statistics. The object of this module is to analyze how the crime incidents get reported and what are the rules relating to reporting of crime in this regard. In this regard, I would like to make a mention of the recent article of Rukmini S. reported in the Hindu of 22nd of August. It has been pointed out in the article that less reporting of crime does not mean that there are less crimes taking place in the society. At the same time, it has also been focused and discussed that more reporting of crime or high rate of reporting of crime does not convey that a society is flooded with crime. And the example cited with regard to offences against women of sexual nature is that of Delhi and Bihar. Now, Delhi has highest crime reporting rate and lower crime incidence, whereas in case of Bihar, Bihar has less crime reporting and more number of criminal incidents. Therefore, reporting of crime demonstrates three things. First, the existence of crime in the society. Second, the empowerment of an individual to report the crime, and thirdly, the willingness of the police officer to register the same. Why crime reporting is important? This question was highlighted and answered by the Supreme Court in the case of Lalita Kumari versus Government of UP in the year 2014. In this case, the Supreme Court has pointed out four major importance of crime reporting. The first and foremost is that it is the first step to access to justice for the victims. Second, it upholds the rule of law. Reporting of crime in any society provides two things. One, it enhances the public trust on the system. On the other hand, it also puts an obligation on those who are authorized or duty bound to report the crime. Thirdly, it facilitates swift investigation and sometimes even prevent the further commission of crime. A crime well reported within time may prevent further commission of crime, and also it may lead to quick investigation in such a crime. And lastly, it leads to less manipulation in criminal cases and lessens incidence of ante-date FIRs. Cases which are reported immediately after their occurrence may not lead to ante-date FIRs, and also it can also prevent any kind of embellishments. Now, methods of crime reporting. We will discuss what are the methods prescribed under the Code of Criminal Procedure for reporting a crime. In particular, the Code of Criminal Procedure provides for two ways of reporting of crime. The first and foremost is by registering FIR under section 154 subclause 1 of the code. Second way is by filing complaint before a magistrate under section 200 read with section 191A of the code. Now, when an FIR is registered, it leads to initiation of investigation under 157 and culminates in filing of police report under 173 of the code. The police officer may also foreclose the investigation under 157 of the code, whereas filing of complaint under section 190 before the magistrate leads to further investigation under 156(3), which will be ordered by the magistrate to the police, or the magistrate may issue process under section 204 if he is satisfied that the prima facie case is made out in the complaint. We will discuss and dwell upon these issues in detail in the latter half of this discussion. Other than these two modes or methods, the Code of Criminal Procedure confers on magistrate under section 191C and police officer under section 157 clause 1 the power to take suo motu cognizance or to initiate investigation in any cognizable offence. First information report. The term first information report is neither used nor defined in the code. An information which is given under section 154 subclause 1 is treated as first information report. It is in fact the information that is received first in point of time, which is either given in writing or is reduced to writing. In the case of Lalita Kumari versus Government of UP, the Supreme Court has highlighted two objects of FIR. The very first object of FIR is it sets the criminal process into motion and is well documented from the very start. Second, the earliest information received in relation to the commission of a cognizable offence is recorded so that there cannot be any embellishment etc. at any later stage. So, thereby if a crime is reported at the earliest, it will serve these two purposes. Now, procedure and elemental requirement for registration of FIR. Now, let us discuss what are the elemental requirement of first information report. These elemental requirements are mentioned in section 154 itself. The first and foremost is that every information relating to commission of a cognizable offence, if given orally, shall be reduced into writing by the police officer. So, in a given case where the informant or victim has narrated the incidents orally, it is a duty of the police officer to reduce the same in writing, and secondly, it shall be read over to the informant. Thirdly, it shall be signed by the informant, and substance of such information shall be entered in the book kept for this purpose. Section 154 subclause 2 makes it mandatory for the police officer to provide a copy of the FIR free of cost to the informant or victim as the case may be. The purpose of clause 2 of 154 is very important. It prevents any embellishment or manipulation or fabrication afterwards. Now, what if the police officer refuses to register an FIR? What is the remedy for this? Section 154 subclause 3 provides that the person aggrieved thereby may send the substance of the information in writing and by post to the superintendent of police, who on receiving such information, if satisfied that the information discloses the commission of a cognizable offence, will direct the police officer concerned to register the FIR. Special reporting procedure. There are certain offences for which the code has prescribed for special reporting procedure. after Delhi gang rape in the year 2012, the code has been amended and certain offences, particularly against women, has been provided with some special procedure for reporting. The first proviso to section 154 subclause 1 speaks that where any information is given by a woman against whom an offence of acid attack, sexual harassment or rape is alleged to have been committed or attempted, then such information shall be recorded by a woman police officer or any other woman officer. Second proviso to section 154 subclause 1 provides that where the said woman is temporarily or permanently mentally handicapped or physically disabled, such information shall be recorded at her residence or at a convenient place of her choice. Such recording must be videographed and such recording shall be taken in the presence of a special educator or interpreter. Now, a question with regard to information under 154 which cropped up a number of times before the court is whether the information need be reasonable or credible in nature, or any information which discloses the commission of a cognizable offence can be reported or registered under 154. So, what is the criteria which satisfies the requirement of 154 of the code? In the case of Bhajanlal versus State of Haryana, it has been held by the Supreme Court that the non-qualification of the word information in the section 154 subclause 1 is for the reason that the police officer should not refuse to record any information relating to the commission of a cognizable offence on the ground that he is not satisfied with the reasonableness or credibility of the information. Reasonableness or credibility of the said information is not a condition precedent for the registration of the case. So, it is very clear from the reading of Bhajanlal that the information under 154 of the code need not to be credible or reasonable in nature. The only criteria it has to satisfy is that it must disclose commission of a cognizable offence. Similarly, in the case of Ramesh Kumari versus State and City of Delhi, the Supreme Court reiterated the principle laid down in Bhajanlal and held that an officer in charge of a police station is statutorily bound or obliged to record an information disclosing commission of a cognizable offence. Again, the Supreme Court has categorically stated that the police officer cannot look into the reasonableness or credibility of such information. Another case in this line is the case of Prakash Singh Badal versus State of Punjab. In this case as well, the Supreme Court has held that at the stage of registration of a crime or a case on the basis of the information disclosing a cognizable offence, in compliance with the mandate of section 154(1) of the code, the police officer concerned cannot embark upon an inquiry as to whether the information laid by the informant is reliable or genuine or not. He shall not refuse to register a case on the ground that the information is not reliable or credible. So, we see that the consistent view followed by the Supreme Court is that the information under 154 need not to be reasonable or credible, and the only criteria it has to satisfy is that the information must disclose the commission of a cognizable offence. Now, the question comes, what is a cognizable offence? Section 2 subclause C of the code defines cognizable offence in the following manner. It simply states that an offence for which, and cognizable case means a case in which a police officer may, in accordance with the first schedule or under any other law for the time being in force, arrest without warrant. So, a cognizable case is one where the police officer may arrest without warrant. As a broad proposition, it can be stated that those offences which are of serious nature and having more than 3 years of imprisonment are treated as cognizable in nature. Another important issue pertaining to first information report is regarding telephonic information, where a police officer receives a phone call and gets information regarding commission of a cognizable offence, whether the information given over telephone can be treated as an information within the purview of 154 or not. This question has been answered by the Supreme Court in a number of cases. To cite a few, Ramesh Bawaji Jadeja case is one of them. In the year 1994, in this case, the Supreme Court has stated that if the telephonic message is cryptic in nature, then it cannot be said that the information which had been received by him on telephone shall be deemed to be first information report. The object and purpose of giving such information over phone is not to lodge the first information report, but to request the officer in charge of a police station to reach the place of occurrence. On the other hand, if the information given on telephone is not cryptic and the officer in charge is prima facie satisfied about the commission of a cognizable offence, then that piece of information may be considered as first information report within the purview of section 154 of the code. Similarly, in the case of Tapinder Singh v. State of Punjab in the year 1970, it was held that where an anonymous telephonic message neither discloses names of the accused nor the commission of a cognizable offence, it cannot be treated as an FIR within the meaning of section 154. The mere fact that this information was the first in point of time does not by itself clothe it with the character of first information report. So, it is very clear by looking into these two cases that the information given over telephone has to be clear and it cannot be cryptic in nature. Therefore, even if it is given first in point of time, but if it is cryptic in nature, it will not be treated as an information for the purposes of section 154 of the code. Another important issue regarding first information report is second FIR. Now, the term second FIR is neither defined nor used anywhere in the code, but practically this question has come before the court many a times for final resolution. As early as in 2001 in TT Antony v. State of Kerala, the Supreme Court has come across with this question of second FIR, and it was pointed out by the Supreme Court in this case that only the earliest information or first information in regard to the commission of a cognizable offence satisfies the requirement of section 154 of the code. Thus, there can be no second FIR and consequently there can be no fresh investigation on receipt of every subsequent information in request of the same cognizable offence. So, it is very clear from this case that where information pertains to commission of the same cognizable offence, all subsequent informations will be considered under the same FIR and they will not be registered as a separate or second FIR. Similarly, in the case of Amit Bhai Shah versus CBI in the year 2013, the Supreme Court has brought the angle of Article 21 to deliberate on this issue. The Supreme Court has stated in this case that there cannot be second FIR in respect of the same offence or event, because whenever any further information is received by the investigating agency, it is always in furtherance of the first FIR. Filing of the second FIR and fresh charge sheet is violative of fundamental rights under Article 14, 21 and 20 of the Constitution. So, the Supreme Court in the case of Amit Bhai Shah versus CBI has stretched the fair investigation and brought it in within the ambit of Article 21, and they have stated that second FIR is not permitted for the same offence or the same event. But on a different note, in the case of Anju Chaudhary versus State of UP, the Supreme Court has held that there cannot be two FIRs registered for the same offence. However, where the incident is separate, offences are similar or different, or even where the subsequent crime is of such magnitude that it does not fall within the purview of first FIR, or it is outside the scope of the first FIR, then in such a case second FIR can be permitted. So, in the case of Anju Chaudhary, the Supreme Court has taken a different stand from the previous views stated in T.T. Antony and Amit Bhai Shah case. Now, let us see the implications of delay in registering FIR. As stated earlier, the information relating to commission of a cognizable offence must be brought to the formal system as soon as possible. The earliest registration of FIR will always prevent any kind of embellishment or fabrication in the information. So, information under section 154 must be given at the earliest possible opportunity after the commission of the offence. Prompt lodging of FIR presumes fairness in the administration of criminal justice. Delay in lodging FIR often results in embellishment, which is a creature of an afterthought and much deliberations. Though delay per se is not a ground for disbelieving the prosecution story. So, it has been pointed out in a number of times in various cases that though the delay per se is not a ground to disbelieve the prosecution story, but as far as possible FIR must be registered at the earliest so that any doubt relating to embellishment or fabrication should be removed. Now, let us discuss the case of Lalita Kumari versus Government of UP 2014 decision of Supreme Court, and this decision is really an important one from the point of view of this module. This was a decision in which the doubt relating to preliminary inquiry before registration of FIR, whether it is allowed or not by the police officer, is discussed in detail, and the court has decided that no such power is vested on the police officer to conduct such an inquiry before registration of FIR, where the information discloses the commission of a cognizable offence. Now, in this case, it was the case related to abduction of a minor girl, father of whom approached the police station for registration of FIR, who was refused by the police authorities, and later he approached the superintendent of police under section 154 subclause 3, who directed the police officer to register the FIR, and after 3 months from the date of missing of the children, the FIR was lodged, but subsequently there was no action taken by the police officer. Frustrated with this inaction on the part of the police, he approached the Supreme Court under Article 32 in the year 2008. In 2008, a division bench has heard the matter and shown its dissatisfaction with the inaction of the police authorities in the state. The court has issued direction to all chief secretaries of the states to bring before it the real data on reporting of crime, and the matter was referred to the larger bench. In 2012, a 3-judge bench decided the case and found that there are inconsistency among different coordinate bench decisions of this court only, by which in some cases a kind of preliminary inquiry are permitted, whereas other cases do allow mandatory reporting of crime. Looking into the need for a decision by a larger bench, the court has referred the matter to a 5-judge bench, and that is how this Lalita Kumari case came in the year 2014. In this case, the court has deliberated upon the issue of providing or giving police a kind of preliminary inquiry before registration of FIR. It has been argued from the side of the respondent that if such a power is given to a police officer, accused right under Article 21 may be protected. It has been cited that in many occasions even registration of FIR against a person may not allow him to either file for passport or he may lose a job if his name appears in any FIR. So, a chance to be given to police officer to check the veracity of the information before registering the FIR. On the other hand, the lawyers of appellant argued before the court that the expression information provided in section 154 does not use the term credible or reasonable. At the same time, the term shall is used in section 154, which makes it mandatory for the police officer to register the FIR in all cases where commission of a cognizable offence is disclosed. Thereby, they rejected the contention of the respondent's lawyer that such a preliminary inquiry can be provided to the police officer before registering the FIR. The Supreme Court, after hearing the arguments from both sides, came to the conclusion that registration of FIR is mandatory under section 154 and given following direction for the purposes of registering FIR and subsequent stages. Now, the very first direction was related to registration of FIR, and it was held that it is mandatory for the police officer to register an FIR under section 154 of the code. The only condition is that the information must disclose commission of a cognizable offence, and in such cases where the information discloses commission of a cognizable offence, the police officer cannot conduct any kind of preliminary inquiry in such situation, and he has to register the FIR straight away. Second, if the information received does not disclose a cognizable offence, but indicates the necessity for an inquiry or a preliminary inquiry may be conducted to ascertain whether cognizable offence is disclosed or not. So, for the limited purpose, preliminary inquiry is permitted by the Supreme Court in this case, but that is only to ascertain whether the information so received under section 154 discloses commission of a cognizable offence or not. Third, if the inquiry discloses the commission of a cognizable offence, the FIR must be registered. So, where the police conducts any such preliminary inquiry and finds that it discloses commission of a cognizable offence, the FIR must be registered. Now, the fourth direction which was issued or given by the Supreme Court in this case was that action must be taken against erring officers who do not register FIR in cases where the information is given with regard to commission of a cognizable offence. And lastly, the Supreme Court has given the direction that the scope of preliminary inquiry is not to verify the veracity or otherwise of the information received, but to ascertain whether the information reveals any cognizable offence. So, this is very important direction, which is the last direction issued by the Supreme Court, that the preliminary inquiry is not for the purposes of knowing or checking the veracity of the information, but it is only for a limited purposes to ascertain whether the offence is cognizable or non-cognizable in nature, and as soon as it is disclosed or it is revealed that the offence is a cognizable one, FIR must be registered. But in the same case of Lalita Kumari versus Government of UP, the Supreme Court has categorized a list of cases in which preliminary inquiry is made permissible. These are the cases in the nature of matrimonial disputes, commercial offences, medical negligence, corruption cases, and cases where there is abnormal delay in reporting the matter to the authorities without satisfactorily explaining the delay. The Supreme Court has set the timeline for such an inquiry of 7 days, and it should not go beyond 7 days, and any delay and the causes of such delay must be recorded in the journal diary kept in the police station. So, even in such cases where the police is conducting preliminary inquiry, they are bound to finish the preliminary inquiry within a period of 7 days, and in case there is any delay, then in such a situation the cause for such a delay has to be entered and recorded in the journal diary kept in the police station. Now, let us discuss the implications of registration of first information report. As you may be aware that as soon as FIR is lodged, investigation takes place. Registration of FIR brings the crime within the criminal justice system, to which judicial authorities have power to be appraised of by the police officer. In the very well known case of H.N. Risbert versus State of Delhi in the year 1955, the Supreme Court has pointed out certain steps which follows registration of FIR, and the very first step is proceeding to the spot. Second, ascertainment of facts and circumstances of the case. Third, discovery and arrest of the suspected persons or offenders. Fourth, collection of evidence relating to the commission of the offence. And last, formation of the opinion as to whether on the material collected there is a case to place the accused before the magistrate for trial, and if so, taking the necessary steps for the same by filing of a charge sheet under section 173 of the code. Now, section 157 provides for procedure for investigation. Section 157 subclause 1 says, as soon as FIR is registered, it must reach to the magistrate without undue delay. This is very important, and it proves to be a check on the powers of the police authorities, and on the other hand, the magistrate is also made aware of the fact that what are the crimes or what are the cases which has been registered in different thanas under his or her jurisdiction. In the case of Arjun Malik and others versus State of Bihar, the Supreme Court has pointed out two purposes for such sending of report to the magistrate under section 157 subclause 1. The purpose and object of sending FIR promptly to magistrate is spelled out from the combined reading of sections 157 and 159 of the code. It has the dual purpose: first, to avoid the possibility of improvement in the prosecution story and introduction of any distorted version by deliberations and consultations, and second, to enable the magistrate concerned to have a watch on the progress of the investigation. At the same time, it must be kept in mind that the police officer is not bound to initiate investigation in all cases registered under 154. Section 157 provides for reasons to suspect the commission of an offence, meaning thereby the code gives power to the police to close a matter before or after investigation. A police officer can foreclose an FIR before an investigation under section 157 of the code if it appears to him that there is no sufficient ground to investigate the matter. Now, what if the police declines to investigate the matter though the FIR is registered? The code provides for remedy in this situation as well. Where an FIR is registered under section 154, the police officer is deemed to initiate investigation under section 157. But if the police officer takes a decision not to initiate investigation, he has to state reasons for doing so. and he is also duty bound to inform the informant about the same. Now, this report will be sent to the magistrate, and magistrate, by receiving such a report under section 158, is empowered under section 159 of the code to take any of the following decision. He may either direct an investigation, or he may direct an inquiry by deputing any magistrate subordinate to him, or he may hold a preliminary inquiry himself, or he may dispose of the case as well. So, even in cases where the police registers FIR and declines to investigate the matter, the magistrate is empowered to take a necessary step regarding the same FIR given under section 159. Now, so far we have seen cases which are of cognizable nature and the procedure related to that. Now, in cases of non-cognizable nature, the police is not bound to initiate investigation. These cases are more of the nature of private wrongs, thereby police investigation is not warranted at the first instance. So, in any case, if a non-cognizable case is reported to the police shall enter the information in the book kept for this purpose and should send the informant to the magistrate. But where the magistrate directs the police to initiate investigation, even in cases of non-cognizable offence as provided in section 155, the police officer shall have all powers, as in case of a cognizable offence, to investigate the matter except the power to arrest without warrant. Therefore, it is very clear that in cases of non-cognizable offence, the police is not required to initiate investigation unless it has been ordered by the magistrate, and if the magistrate orders so, the police officer is conferred with the same power as in case of cognizable offence except the power of arrest without warrant. Now, the second method which we have discussed in the beginning is reporting the crime through complaint mode. To dwell upon this issue more, let us see what is complaint, by whom it can be filed, what is the procedure followed after the filing of complaint, and other issues. Now, complaint can be filed by any private person or government officials as required under various legislations like Minimum Wages Act, Contract Labour Regulation and Abolition Act, Child Labour laws and environmental laws, etc. However, in some legislations, complaint mode is made the only way to initiate the criminal proceeding. Two things should be kept in mind while dealing with complaint as a mode of reporting of crime. First, as it is required for first information that it is only with respect to cognizable offence, complaint can be filed in all types of cases regardless of their nature being cognizable or non-cognizable. Therefore, a complaint can be filed by any person or government official, as the case may be, with regard to commission of a cognizable as well as non-cognizable offence, with regard to commission of a cognizable or non-cognizable offence. Secondly, any individual may file a complaint before a magistrate irrespective of the fact that whether he has moved to the police officer first or not, meaning thereby the magistrate can be approached at the first instance. Secondly, the magistrate can be approached even where the police refuses to register FIR. Now, magistrate can take cognizance under section 190 of the code. 190 speaks of three different types of cases by which the magistrate may take cognizance of the offence. The first is upon receiving complaint of facts which constitute such offence. Section 190 subclause 1 subclause A provides that a magistrate may take cognizance upon receiving a complaint of facts which constitute such offence. Clause B of subclause 1 of section 190 provides that the magistrate may take cognizance upon police report of such facts. Now let us discuss the steps which a magistrate can take after receiving of complaint under section 191 subclause A of the code. Now the magistrate may either direct police to investigate into the matter as per section 156(3), and he must record his reasons for doing so. Alternatively, he may take cognizance of the offence under section 200 read with section 191A of the code. Where the magistrate directs an investigation under section 156 clause 3 of the code and police files a report under section 173, he may take cognizance of the offence under section 191 subclause B of the code. But where police submits an adverse report to the magistrate may take any of the following recourse. He may drop the proceedings and dismiss the complaint. Secondly, he may not agree with the police report and may take cognizance of the offence on the basis of the original complaint filed under section 191A of the code and proceed to examine the complainant and witnesses as per section 200. He may reject the police report and direct an inquiry under section 202 of the code, and after such inquiry may take a decision as per section 203 of the code. On the other hand, where the magistrate takes cognizance of the offence under section 200 read with section 191A of the code, he has following recourses to comply with. First, he shall examine on oath the complainant and witnesses present and record the statement and evidence of the complainant and witnesses as per section 200 of the code. Second, if he is satisfied that there are sufficient grounds for proceeding, he can straightaway issue process as per section 204 to the accused. Third, if he finds from the evidence led by the complainant that there is no sufficient ground for proceeding further, he shall dismiss the complaint as per section 203 of the code. And lastly, the magistrate can postpone the issue of process and direct an inquiry into the matter by himself or by any other person, or an investigation by the police under section 202 to ascertain whether or not there is sufficient ground or evidence to justify the issue of process. So, as we have seen, as and when the magistrate receives complaint under section 191A of the code, he has two recourses to take. He may either send the complaint to the police under section 156(3), or he may initiate process under section 200 read with section 191A of the code. Where the magistrate directs an investigation by the police under section 156(3) of the code and police submits a report under 173, the case gets converted from a complaint case to a case on police report, and the magistrate will take cognizance on such a police report under section 191B of the code. And where the magistrate gets an adverse report filed by the police officer assigned the duty of investigation under 156(3) of the code, he, as we have seen, has three recourses to take. And on the other hand, where he takes cognizance of the offence under section 200 read with section 191A of the code, he has four recourses to take, and thereby this shows that on a complaint what are the processes or procedure which are involved and required on the part of the magistrate to take. In the case of Vasanti Dubey versus State of MP in the year 2012, the Supreme Court had said that even if no case is made out in the police report, the magistrate could ignore the same and could take cognizance on applying his mind independently to the case. In doing so, he has two options. One, he may reject the police report and direct an inquiry under section 202 of the code, and after such inquiry take a decision under section 203 of the code. And second, he can take the cognizance of the offence on the basis of the original complaint filed under section 191A of the code and disapproves the police report. Now, what is the procedure to be followed where the magistrate takes cognizance on complaint? The procedure laid down in section 202 is to be followed in cases where the magistrate takes cognizance on complaint. It provides that the magistrate must examine on oath the complainant and the witnesses present. Secondly, the substance of such examination shall be reduced into writing. Thirdly, it shall be signed by the complainant and witnesses if any present. And lastly, it shall also be signed by the magistrate. Now, as we have seen that the code has provided certain special procedure for reporting of crime with regard to victims of sexual offences, acid attack or rape. Another important development which has taken place in the year 2013 and by the recommendation of Verma committee, new provision has been inserted in the Indian Penal Code, which is section 166 capital A subclause C, which is relevant and important from the point of view of this module. Section 166A subclause C provides that if a police officer fails to record any information given to him under section 154(1) of the code in relation to offences of acid attack, sexual harassment or rape. Similarly, the Protection of Children from Sexual Offences Act of 2012 is worth mentioning here. Section 19 subclause 2 provides for criminal sanction for against the authorities who fails to report the matter. So, therefore, these sections have really strengthened the criminal justice system as far as the reporting of crime is concerned. Now, let us go back and see what all we have discussed in this module. It can be seen from the discussion so far that the code stipulates mandatory registration of crime by the police. The doubt over scope for conducting any kind of inquiry before registering FIR has been clarified by the Supreme Court in the case of Lalita Kumari. And now the position is that in all cases where the information discloses commission of a cognizable offence must be registered by the police officer. Similarly, in those cases where the victim is woman and the cases are in the nature of acid attack or sexual harassment or rape, a special provision is enacted or inserted in the Indian Penal Code providing for penal sanction for the erring officers. This is a very welcome step which also encourages the public, especially the women, to come before the formal authorities to report the crime. And at the same time, it is also seen throughout the discussion that though the registration of FIR and investigation are executive functions, the court, to make it sure that such powers are not exercised arbitrarily, incorporated scrutiny by courts over such powers of police at various stages. We have also seen where police submits an adverse report in any investigation that is not the final, and the magistrate has been empowered to review that report and take a different stand. Altogether, it can be said that the Code of Criminal Procedure has been well drafted and responded to the cause of crime reporting by providing different mechanisms to invoke the criminal justice system. But sadly, the public is not coming before the authorities to get their crimes reported, maybe because of the apathy shown by the police officer or because of the fear of the machinery of criminal justice as it is functioning today. But we all hope that the insertion of 166(8) subclause C kind of provision will surely encourage public to report the crime or to bring the crime before the formal authorities. Thank you.